the Board of Mortgage Loan Originators. It is September 17th, 2005, and the time is 9:01 a.m. This is a public meeting of the Board of Mortgage Loan Originators. We will now call this meeting to order. Let's begin by having the Division Director perform our roll call.
Aaron Saladay.
Here.
David Williams.
Here.
Shirley Thielen.
Here.
Josh Bradback.
Present.
Natalie Lawson.
Here.
You have a quorum.
So do you want to just talk about the board meetings, or do you want to jump into the rulemaking?
So we should probably lead off with the rulemaking.
Okay, absolutely. All right, good morning. I'm Aaron Saladay, Chair of the Board of Mortgage Loan Originators. Could you please, oh, we did that. We have a quorum. Today is Wednesday, September 17th, 2025. It is now 9:01 a.m. This is a permanent rulemaking hearing pursuant to the Administrative Procedures Act, found at Section 24-4-103 of the Colorado Revised Statutes, to hear oral testimony and accept written submissions related to proposed amendments concerning the rules governing the practices of mortgage loan originators of the Board of Mortgage Loan Originators, referenced in the Code of Colorado Regulations as 4 CCR 725-3. Section 12-10-722 of the Colorado Revised Statutes authorizes the Board of Mortgage Loan Originators to promulgate and amend these administrative rules. This permanent rulemaking hearing is being conducted pursuant to the process as set forth in the Administrative Procedure Act. During this hearing, the board will hear testimony and accept written submissions in regard to amending Rules 4.1 and 4.2 with respect to the license renewal and reinstatement requirements. In addition to my fellow board members, here with me today are Directors Marcia Waters, Deputy Director Garrett Lyle, and Senior Advisor Melissa Phipps from the Division of Real Estate, Education, Communication, and Policy Manager David Donnelly, and Anthony Lally from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable timeframe. Therefore, in addition to all of the public comments today, the board will review all written materials to make their final decision on the proposed amendments. The public record will close at the end of this hearing. Let's now have Director Waters explain the proposed amendments to Rule 4.1.
So board members, Rule 4.1 outlines the process for mortgage loan originators to renew their licenses. The existing rule references having to renew on two databases, the NMLS and then the state's e-license system. What we are proposing to do with modifying this rule is to strike that requirement and only require licensees to renew on the NMLS. The NMLS will collect our licensing fees and remit those to us. It's basically just going to streamline the process for the mortgage loan originators, and then we will take on the burden of reconciling the two databases as far as renewals are concerned. Do you want to go into comments about this rule first, or would you like me to go ahead and give you an overview of 4.2 as well?
Board?
4.2 would be great, so we can kind of think about it all together.
Right.
Okay, so 4.2 addresses the reinstatement process. This is when your license expires and then you are coming back within that narrow window of time that you can reinstate. The existing rule again references having to reinstate on both databases, the NMLS and then our e-license system. Like the renewal rule, we are recommending that you strike the language about both databases. They'll only have to reinstate on the NMLS, and then we will reconcile our records to match the NMLS. Again, it's to streamline the process for the mortgage loan originators.
Thank you for that explanation, Director Waters. At this time, we will start with testimony phase of the rulemaking hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identity. Identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed rule amendments and do not duplicate testimony. Should the board or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on.
Thank you, Chair Member Saladay. If any members of the public would like to speak, please select the raise hand icon in the Zoom tool menu, and we will be able to unmute you. So, board members, if we can give that a few moments here, see if any individuals would like to address the board. However, I'm not seeing any hands.
All right. Well, I guess what we'll do is just talk amongst ourselves real quick on what we saw and what we were given. Does the board have any questions or any thought process with this? I'm totally in favor of it. In my opinion, I think a lot of our investigations require the investigator to look, and our applications are not in line with the NMLS. So sometimes we'll have something that's not on there but was on NMLS. So to me, it's actually freeing up a lot of our space as the board. Besides being a licensee, it makes it a lot easier. You're not hoping and wishing that Colorado does it and NMLS have it. It's just one board to go to. So I'm totally in agreement with this.
I agree.
Go ahead.
I agree. I'm 100% in favor of this. I'm all for streamlining, and having two systems has really created confusion in the past as to where applicants would report something in one place and not in the other. And it's, I'm 100% in favor of this.
So board members, just to be clear, I don't think it's going to resolve that issue.
Oh, okay.
Because we aren't switching the full-blown brand new applications over to just NMLS.
Gotcha.
Maybe at some point we can look at doing that, but I will tell you, we lose 15 to 20% of our renewing population annually because they are so confused about having to navigate two different systems. So we have a ton of call volume going into renewals, and then it's a lot of work on the back end when people have dropped off. So while this adds to kind of our duties, I think it will kind of equal out in the end. And at some point, hopefully, when we're looking at transitioning to a new database, we can take into account the possibility of having them only navigate one on the initial applications, but we're just not there yet.
Understood. Well, baby
At least it could be a
steps.
good step.
Right. And we still would have to go in, the loan officers still have to go in and put in their insurance and surety bond on the website for Dora? Or you're going to change that?
I don't know that is going to be required after this change.
Okay.
Right.
It's still going to free up a lot of time for them.
I
It's going to
agree.
streamline a lot of it.
In all favor for it. Especially if you can just pay in one place and, we don't have to do two different ones.
Yeah, for sure. Board Member Lawson, do you have thoughts or you like?
Same. I love it. I think it's one less step for us all to take when we're already doing so much kind of at the end of the year. So not having to go into the Dora website would be really great. One less login, I hope, but I think we still need it for applications. But yeah, every year the login, you're like, oh my gosh, what was it? And yeah.
Yeah, always changing that password. So
Yes.
Right.
for sure. Yeah. Board Member Broadbeck?
I concur with everything I've heard. So with that said, I'm happy to make a motion to approve the amended rules as submitted.
Okay.
I'll second it.
A second. So I have a second to approve the amendments to Rule 4.1 and 4.2. I'd like to do a vote. All those in favor, say aye.
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 All right, and I am also an aye. All those opposed, say nay. All right, looks like it's unanimous and the motion passes. All right, this concludes the rulemaking hearing. Thank you. All right, so let's go on. All right, so we're going to look at the approval of the July 16, 2025 minutes. Did everybody have a chance to review these? Is there any adjustments or any conversation we need to have over them?
Nope.
Good to me.
I'll make a motion to approve as submitted. I'll
Okay.
second.
All right, all those in favor to approve minutes? Say
Aye.
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 All those, and I'm also an aye. All those opposed, say nay. All right, the motion passes. All right, at this point, I would like to enter into executive session. This is the Board of Mortgage Loan Originators. It is September 17th, 2025, and the time is 9:11. I move that the board enter into executive session pursuant to Colorado Revised Statutes Section 24-6-402 3A(i)(i) to receive legal advice on Policy Matter B, Shared Appreciation Home Equity Agreements. I move that the board also enter executive session pursuant to Colorado Revised Statutes Section 24-6-402 3A(i)(i) to address questions concerning the legal requirements for discipline and the legal requirements for licensure regarding investigative matter A, complaint number 2025-718, licensing matter C, complaint number 2025-1037, licensing matter D, complaint number 2025-1311. Can I get a second on the motion?
A second.
Okay. All those in favor say aye.
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 All right, I am also an aye, and those opposed say nay. All right, the motion passes. The board is exiting the public meeting to convene in a closed executive session conducted remotely. We'll be back shortly.
Doesn't look like I can turn my camera on. It says I've been blocked.
Just one moment, Board Member Williams, and I'll get
Okay,
that for
all
you.
right, thank you. I was doing something wrong.
Nope.
Just glad I could get back.
Here we are. All right. Board Member Williams and Board Member Broadback. Oh, there you are. Board Member Williams, great.
Thank you.
Let me know when everybody's back. I can only see 4 if you can.
You are all back.
Thank you very much. The time is 9:57 and the board is now back in open session. We'll enter policy matters and I'll turn this over to Director Waters.
So board members, the first item under policy matters is selection of leadership. It is that time of year for you to select a chair and a vice chair.
So I guess the question is, does anybody want to do it?
And do you want to do it again, Aaron?
I've been pretty busy, and I would definitely be a vice chair, or I could probably even stay if no one wanted to do it. But I'd like to step back a little bit with what I've been doing. But if someone else would, take it, I would definitely help support them in their new role.
I have zero desire to be either. So as I mentioned last year, but I, of course, will do what is necessary.
Exactly. So if the new 3, if you guys are not interested, obviously we can have a conversation too. So no big deal.
Natalie, your interest?
I'm not very, I feel still very new and like I'm still learning so much of this. So I don't necessarily
Okay, well,
know.
I will jump in, Aaron, and help you out.
Thank you.
You all are patient with me.
So do you want to
That's
be
awesome.
chair?
I'll be chair if you want to be vice chair.
I would definitely back you up if that works for everybody. I'm sure
Josh,
we'll
do you have any interest? Don't want to leave you out.
Well, if Dave and Aaron are good, what I was going to say is I feel too new to step up for anything like chair. I would be fine with vice chair. But what I would say is that for matters of transition, it's probably smoother for us as a board. If Dave wants to step up to be chair, I think it makes more sense to have a former chair serving as vice chair to make a smoother transition for all of us. So since it sounds like Dave and Aaron are willing to do that, I would like to move accordingly.
That makes a lot of sense.
Okay,
So I nominate David Williams as chair and Aaron Saladay as vice chair.
And I'll
Second.
All right, let's have a vote. All those in favor say aye.
I
Aye.
I am also an aye. So the motion passes and the positions are filled. Thank you, guys.
Thank you.
and that starts when?
Next meeting.
Next meeting, okay.
Board members, the next item under policy manager or policy matters is shared appreciation / home equity agreements. The division would like some direction from you all about how you would like to address these. There's a lot of disparity in the types of agreements out there. I don't think that they fit cleanly under your regulations. What the division was thinking that it may be helpful to the industry for you to do a position statement to at least kind of help them evaluate which activities would actually fall under the mortgage loan originator's license. Most states, it appears, and there's not very many of them, have handled these types of products by modifying their statutes. So that specifically they do fall under the kind of definition of a mortgage loan, we've kind of missed the window of time to submit a legislative proposal for 2026. If it's something that you're interested in pursuing, I can definitely submit a legislative proposal after the 2026 legislative session. And another thing to also contemplate is whether you want to do a definition of what a mortgage loan is. You've got definitions of loan modifications, but you don't have an actual definition of a loan. I provided you with a few different resources. One was a draft article. It's just a draft. We have not sent it out. It was an informational piece that's been kind of waiting in the wings. But I didn't feel confident in just automatically going down the rulemaking route and assuming that these are all going to fall within the board's jurisdiction. And there are legal concerns as well. If you assert jurisdiction over something that does not fall clearly under your authority, you can be sued by the Federal Trade Commission, and I don't want any of our boards to have that experience. I would rather watch that
Thank you.
unfold in other states. So if you could just give us some direction on what you'd like to see, that would be helpful for us.
Well, I think it's very important to define what a loan is to us, first off, because that's what we deal with. And in my mind, it's a thing that is borrowed, especially some kind of money that is expected to be paid back with some added value. So to me, these are basically portions of that. I've actually dealt with several of them in my industry. So I definitely have been well aware of what they are.
I
I agree.
also agree.
Same here.
I agree that it's a loan. I mean, it's a loan. It's tied to a residential mortgage, or sorry, residential property, and will be paid back. And nobody's just giving out money for free. So I would definitely consider these to be a loan.
Absolutely.
Yeah, I agree. It's not a gift, and whether it's the full principal, appreciated value, whatever definition of the different ones that come in, it's still there's an expectation of repayment.
Yeah, and I think what the definition we have shows that it's a loan, it's personal, it's for personal use, and it is secured by the mortgage deed. So I think some of the previous that we've heard is that some of the judges have said that there's not a guarantee of payback. And that's one thing I would really, and obviously there's a lot of gray area because we don't see these being signed until someone does them, because they're not a standard document like some of the stuff we have in Colorado. So they're all going to be totally different. And every one of them, depending on who wrote it, has a different paybacks. Maybe they have a term, or maybe they don't have a term, and maybe they go to the successors and assigns. And, so it definitely can be crazy. But I think the definition of these to me, and obviously sounds like to the board, is that it is a loan, since it is recorded for personal use, and then it is, the terms of it.
Well, I'd like to add, I agree 100%, but I'd also like to add that there's been an argument that because there's no guarantee of repayment, I think the key is that there is an expectation of repayment. And that, to me, is the key difference, is it's still an expectation of repayment. And I don't know who said it, it's not a gift.
Right.
And I agree, it's definitely a loan based on the things that you outlined, Aaron.
Well, and the expectation is there because it's recording a deed of trust. So it is a lien on the property that's going to come under, whether the property is sold or there's a foreclosure proceeding, it's going to have to be addressed one way or another as a loan.
Correct.
Simply because there is some speculative nature to these types of agreements. That is just simply one of the terms of the loan. There's all kinds of speculative terms in loans all the time. If this happens during the life of the loan, well, then here's how we'll handle the transaction from that point forward. That happens all the time. So simply because there's not a guarantee of repayment does not negate the fact that it's still a loan. So, I mean, my feeling is that we, to help matters out, to help the division out, but then also to help the legislature when they get active on this in passing a law, I think if we just make it clear that we reviewed the issue and that we consider home equity, shared appreciation, and home equity agreements to be loans. There's just not a question. They're loans. And I mean, I think that's probably the easiest step we can take right now is just issue that simple policy statement. These are loans.
And request that the division then refer this to the legislature for statute or whatever statute amendment.
I think that's what we can do for sure. Is that what you're looking for, Marcia?
That's very helpful. And so I also heard that you also want to look at having us do a rule definition for you of what a loan is.
That would
Yes.
be great.
Yes, please.
That is what we needed. So
Okay.
the last item under policy matters is, do you have any agenda items for the next meeting in November?
I do not.
I do not either.
No.
Nope.
Thank you, board members.
Thank you. All right. Now we'll go into citizen participation period. Do we know if anybody's wanting to talk to the board at this point?
Board members, there are several attendees at this current time. So any attendees that are here that would like to address the board, please, again, similar to the direction earlier, you may select the raise hand icon in the Zoom platform menu, and you may we can identify you and you can bring your comments to the attention of the board. So if we could just give that a moment, board members. Again, not seeing any hands here, board members, so I'll pass it back to you.
Thank you very much. All right, we'll move to complaint matters. All right, we'll turn this over to the investigators.
Good morning.
Good morning.
Good morning.
Morning.
Complaint matter A is complaint number 2025-718. In February of 2025, a whistleblower complaint was filed with the state regulatory registry, alleging that the respondent allowed the whistleblower to complete education courses for the respondent. On March 31st, 2025, the SRR decided to retract 25 courses completed between August of 2024 and February of 2025. The respondent informed the division that he would be appealing the decision. On June 16th of 2025, the appeal was denied and the original discipline upheld. The division was originally notified of this matter through the NMLS alert. Possible violations include 1210-713-1Q, unworthy incompetence, 1210-713-1V, good faith fair dealing, 1210-713-1X, unfair deceptive practice, 1210-713-1R, obtain license with false info, 1210-713-1W, discipline in another jurisdiction, 1210-713-1A, misrepresentation, misleading advertisement, 1210-713-1C, misrepresentation, false promise. And we do not have a disciplinary recommendation, but Investigator Martinez is here to answer any questions that you might have.
I'd like to recluse myself from this discussion.
I do have a question. Why no recommended discipline? That was the first thing I noticed. Why does staff not want to make a recommendation in this case?
And board members, if I can jump in, I just wanted to remind you that you've been alerted to efforts of multiple states to engage in a multi-state enforcement action. And what we're asking from you today is discussion about the details of this case, the appropriateness of the stated violations, and then through your discussions, a disciplinary recommendation, and then further direction to the division if you would like to have that disciplinary recommendation proceed through the standard enforcement and settlement process, or if you would like to refer this to the AG's office to participate in any subsequent negotiations for participation in that multi-state enforcement action.
Is that for this case or another case down in licensing?
No, that's this one.
That's this one.
Okay.
Okay.
So the only discipline that we could give is not like we're maxed out at, what is it, $1,000 or $2,000?
It's
That's
per,
$1,000.
yeah,
I thought it was 3
It's $1,000 per violation.
per
Oh.
violation. That's right. Okay.
So there was several violations that this could fall under.
We can also
Right.
take action on the license, correct?
Yes.
Okay.
Well, I mean, I think it's pretty clear from the facts and the fact that it's been appealed and upheld that, you know, this respondent had someone else take the classes for him. And I think that is definitely falls under, you know, obtaining a license with under false information. And I just think it's very misleading. I think that participating in a multi-state resolution, because this is affecting a bunch of different states, is a good thing, but I don't want to delay a decision because I think this is pretty egregious.
I have to agree, Shirley. I think that there's no reason why we can't do both. Why we can take action today based on what we have in front of us for the state of Colorado. And then with the knowledge that there are other actions in process in other states because of the same thing, then we have a willingness to participate in those as well. I don't see any reason why we can't do both. Another way to look at it is that pretend for a moment that everything was equal, except this did not involve other states. The idea that we would treat this respondent differently than we would for someone who was only licensed in Colorado, to me, that doesn't make sense. That's inequitable. So my recommendation to the rest of the board is that we go ahead and take action on this one as we normally would. And then with respect to what's happening in other states, we throw our hat in the ring as well. I didn't hear any reason why we can't do that. So that's my sense.
I guess the only thing that would occur there is that if we decide to suspend or revoke the license, and then the states, I'm just trying to think this through, then the states all agree on some other discipline, then this individual would be able to get their license reinstated subject to whatever the joint state agreement is. Is my logic correct?
My understanding, and I'm not the attorney on the line here, so tell me to shut up, legal, if I need to. But my understanding is that if we were to participate in the multi-state litigation, we would be a party to that, and so there would be a representative in some way from either this board or the division that would be representing us as a party to that litigation, the same way it would work like in a mediation or anything else. So that person would be authorized to negotiate on our behalf after the fact. But again, I'm not from the AG's office. I'm just going from experience that I had with the Colorado Real Estate Commission.
Yeah, and maybe Anthony can step in and express a little bit more detail about what the involvement of the Attorney General's office would be in that circumstance.
Yeah, so thank you. So board members, if regardless of how you wish to proceed with discipline, our office will get involved. We represent you all in your litigation enforcement capacity. If the board is interested in at least looking, not necessarily, looking into this joint state, this multi-state settlement, that is something that council can look into as part of preparing this case, disciplinary case for litigation, assuming that the board does vote on discipline, or vote to impose discipline. The thing that our office will need and that the board will need to decide is at this stage three things. One, what are the violations, if any? Two, what discipline does the board think is appropriate for those violations, if any? And then three, does the board want its counsel to at least look into the multi-state settlement or just proceed as normal as a traditional disciplinary case? Those are the three questions that are before the board that the board will need to address.
Okay.
I had a question earlier about why staff chose not to make a recommendation for discipline. Can someone enlighten me?
Whenever we have previous cases that have similar fact patterns and we can point to kind of a historical perspective of what the discipline has been, we'll go ahead and include that as a disciplinary recommendation. We felt that the fact pattern of this was unique enough that we wanted the disciplinary recommendation to come from your discussions about what was appropriate.
Oh, understood. Okay, thank you.
So this kind of, to me, mimics Reese back in the day. The new board
Yes.
members don't really know about Reese, but there was a company that gave people licensure credits, the CEs, but they didn't have to attend. So we had quite a lot of those cases back, and I think it was 21, 22,
Yeah.
maybe. So obviously that would be something I think we probably want to be similar, at least go along with that. Is that something that sounds right to you, Shirley?
It does. I was thinking the same thing, and I was trying to remember what we did with those. Do we have any recall there? I'm trying to go back to some notes here.
Me too.
Should have done this earlier.
I don't. Oh, here we go. We did probation, I thought, for 180 days with the licensure, something like that. But I don't. This is a little bit different than that, though, too. So.
I think it's different in that the Reese thing, if I understand it correctly, was like this company that said, hey, pay us this. And so it didn't feel as, I don't know how to say it, like it's a company that says, we're going to give you this, but you're not going to do the whole time. This guy actually had this person doing the classes for him because I guess he's maybe too important to do the classes himself. He has the privilege of being licensed in many states, and it's a privilege, not a right. So he should take it a little bit more seriously and be grateful to take those classes. All of us have to take those classes every year. And if we're getting paid in multiple states, then we also have to put in the time, in the hours. And then the fact that he's appealing it all and lying when she clearly took the classes for him based on the text messages that I saw.
Yeah.
Like it's like he's above the law, in my opinion.
So do you guys have some recommendations, what you would like to see? Because it clearly isn't a Reese, but
Yeah. But similar. I still see the similarity. Yeah, it's like lying about your education, right?
Right.
So procedurally, Mr. Chair, what I would ask is that we will go ahead and decide what we want to do on discipline first, and then we can decide what we want to do, what next part is separately. Just because trying to do all that in one motion would probably be so messy, none of us would understand it. So if you're with me so far, what I would like to do is make a motion that we fine the respondent $7,000 and revocation of license.
and that's per, so there's $1,000 per.
Yes, sir.
And sorry to interject, just point of clarification. It sounds like board member Broadbeck that you would want to adopt the proposed discipline that's cited in the ESP referral that you received.
You know, I apologize. I don't have that right in front of me. Give me a moment.
So we would just need to list those out if that's the one. But are we?
And you don't, sorry to interject one last time, you don't need to recite them all. If you just want to adopt at least the disciplinary bases from the ESP, you can just say so. Since those are, been read out and identified, it'll be clear for the record.
Oh, okay. So I'll restate the motion. Is that
Before
what
you
you're
do the
asking?
motion, sorry, Josh, before you do the motion, I did have a comment on a couple of those. So two of them that are listed refer to misleading advertisement and making false promises through agents, salespersons, advertising, or otherwise. I agree with the first five. I don't think that those are as strong an argument and to deny a license based on the facts of this. So I would, in my opinion, suggest that it's the five first violations that are listed and do away with the advertising references just for clarity.
And board members, sorry to interject one more time. The two bases that were just identified by board member Thielen is 713(1)A, and that states knowingly making any misrepresentation or knowingly making use of any false or misleading advertisements. So there are two components to that. And then 713(1)C, the other bases, says knowingly misrepresenting or knowingly misrepresenting or making false promises through agents, salespersons, advertising, or otherwise. Just point of clarification for the board's discussion.
That's a good point with the or. I was not reading that clearly.
Those fall back in line better for you?
Yeah. Okay. So I'm with you, Josh.
Okay, so
And I'm sorry, board members, if I could jump in. I just wanted to remind you that you would also need to provide direction as to diversion, final agency order, or public censure.
okay.
And what about, I mean, are we all on board with the revocation? Because the Reese one, those cases were not revoked. Or those licenses were not revoked, I believe.
From listening to everyone else, I'm convinced that this is different enough from the Reese matter that you've mention that this would, in my mind, this would justify a revocation.
I'm not in disagreement, but at the same time, it is like, it's harsh,
It's something we can't take back, right?
right?
Yeah. And that's what's tough for me too, because, but I mean, knowingly pay someone to take your classes and a Reese matter is different. Like, it's just, I'm toying with what is the right one. It's very difficult to.
He clearly didn't take his license seriously, right? But I do think a $7,000 fine and public censure. I mean, does he even still continue? Does he decide to let Colorado go at that point?
Yeah. So do you guys have your definitions of what those are? I could read them out if we need them.
That would be great.
So a public censure would be public notification in the division's newsletter and on the list of disciplinary actions listed on the division's website, not within the licensing database of a licensee's misconduct and resulting discipline. Revocation would be the punitive loss of a license, professional license, as a result of misconduct. And if we revoke it, I believe that he can never ever apply again. Plus, it would also, I believe, and you guys can correct me if I'm wrong, I believe it would almost automatically take his other licenses in other states too.
Mm-hmm.
There is also a relinquishment, which is an individual surrender of a license, which may or may result from allegations of misconduct and the abandonment of the ability to perform the acts that require a professional license. And there's also restricted license. So we could get some more information from our AG Lally and see what would be something that if we don't want to be as harsh as a revocation, because there are other stuff going on in other states, we could see what his recommendation may be on one of those.
I think the other thing is in Colorado, I mean, he has to take the classes. I mean, this is fairly recent that, this all happened. So has he actually taken the classes? And that would be definitely a term of whatever we decide to do if it's not revocation.
I don't think he did, but Investigator Martinez, do you know if he is?
These allegations were not specific to Colorado education, and we did outline that.
Oh, I missed that then.
Yeah, me too.
And board members, the discipline is entirely it's within your purview. It's not my place to recommend what the board can and what the board should do in this situation. I'll just reiterate that the potential options for discipline include revocation, license suspension, public censure, fines, and or probation. I believe those are the big 5 options that you have. And the fine amount, I believe you already identified. Since it's the first instance of discipline, it would be $1,000 per act or occurrence. Those are your big options here, or your main options here.
Can you tell us what the suspension is? Like, is that just you're suspended for 2 years and then you can come back to us?
Yes, yeah, I believe that's typically how that works administratively. I would defer to division staff on exactly the mechanics of it, but that is my understanding.
Okay.
And I
So
don't
if you
think it's
specify the period of time, then they don't get to practice, do anything that requires that license for that period of time. And if they do, then they'll come back to you as a step violation.
so
Is
Mark,
there sorry, go ahead.
so if we said the suspension as of today for 2 years, is it today or does he finish out the year? I can't remember.
So it doesn't go into effect today. I mean, it would depend on whether he signed the stipulation that gets sent to him. If he signs it, it will go into effect the date of his signature unless he negotiates something different with Penny. But then he would be suspended for 2 years. If he doesn't sign a stipulation, it would go to hearing. Likely it would be Anthony litigating it, and we would have to wait until the full court process goes through. And if an ALJ agrees with the board that he needs to be suspended, and it doesn't go through an appeals process, then the suspension would go into effect once the final order is issued. So he could be practicing for quite a while, like up to 2 years, while the administrative court process plays out.
But the revocation is the one that's immediate, or as soon as possible. It's the quickest one.
Oh,
No, it's the same as the suspension. If he signs the stipulation, then the revocation would go into effect. Otherwise, if he litigates it, it would have to go through the whole administrative court process before a final order is issued. And if the final order says that he's revoked, then the revocation goes into play.
Thank you.
And I'd like to point out to my fellow board members that what really has me so concerned here is that this respondent, even though his hands were effectively caught in the cookie jar, keeps denying it. I mean, it not only is it egregious to the point that Shirley made earlier, but he keeps denying it to other organizations, even after being investigated over and over again. And since we know that no discipline that we take is going to be instantaneous, and it will obviously be appealed, I don't know why we would give this person an opportunity when we know what's going to happen.
That's a good point, because most of the applicants in the, I call it the cheating scheme, admitted that, they
No, it was wrong.
Right. Which says, it speaks to character. So I think I agree with Josh, the fact that he keeps denying and has no accountability for this whatsoever is really concerning.
Mhm.
That is a good point, and that I appreciate you bringing that up, because that does, I had forgotten about that point. So, okay, thank you. So, any other inputs, or do you guys want to make a motion?
I will make a motion that we fine the respondent $7,000, $1,000 for each of the listed violation on the ESP referral document, and for revocation of license and public censure. I think I covered them all.
Do you
Right.
want to refer also to the attorney generals, or just want to be finalized?
Would we do that here, or would we do that as a separate action?
I believe we would put that into the motion.
Okay, then I will add to it referral to the attorney general's office.
Do I have a second?
I'll second that.
Okay. Do I have a vote? All those in favor say aye.
Aye.
Hi.
I am also an aye. The vote passes unanimously.
The board members, can we get some clarification? Because referring just to the AG's office, that regularly means start litigating, Anthony. But I think what you were also had been kind of contemplating was you can set your own disciplinary standard, but you could also refer it to the attorney general's office and allow Anthony basically to negotiate on your behalf to join potentially the multi-state disciplinary proceeding against this licensee.
Yeah, I apologize about that. So do you want to re-add that to there? Do we need to just have a new vote on that, or can we just add that to it after?
Well, that's why I was suggesting earlier, maybe we keep the two separate. And we'll talk about the AG and how or if we want to ask the AG's office to move forward, because unlike other matters, we have like more than one option here because of this multi-state litigation that's happening. This one's got hair on it, is what I'm saying.
So I think it's clear to us that on the board level, you want $7,000 fine, revocation, and public censure. So I think if you guys can kind of vote to clarify that that is your separate motion, and then do a second motion on how you want Anthony to deal with this.
Okay,
Okay.
all right. So we'll make a new motion.
So I'll make a motion that we fine the respondent $7,000, $1,000 for each of the listed violations on the ESP referral, revocation of license, and public censure.
I have a second
I second.
and I have a vote. All those in favor say aye.
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 I am also an aye. All right. That motion passes. And then do we have a second motion for the Attorney General office, or you want to talk about that some more?
Well, I had another thought. Oh, sorry. Go ahead, Natalie.
I was just gonna say, if we have come to an agreement on what we want done for Colorado, what would be the point in referring it?
Well, the other issue is if this did not occur in Colorado, why would we
Why would we care?
spend the resources to be involved in that?
Right.
Yep, I agree with that.
Well, so I think if you allow the Attorney General's office to represent you in kind of settlement negotiations at the state level, that may actually be more likely to resolve it that way than maybe what you individually think should happen to him should he not agree to the multi-state settlement. I would expect if I was in his shoes, I would probably go with the multi-state settlement versus what you guys are ordering. So it could end up saving you some legal expenses if you give him the authority to delegate a resolution with the other states on your behalf.
Oh, I see. Because it would override then what we are doing now if
it kind of also forces their hand. They can pick one. Pick one's most attractive. You end up getting your case resolved, and it could result in a resolution of your case without Anthony having to actually litigate it.
On it.
Okay, that makes sense. Yeah, I like the efficiency model.
And board members, if that's the option you want to, if that's the route you would like to go, for purposes of a motion, my suggestion would be something along the lines of, motion to direct the attorney to direct litigation counsel to explore potential settlement through the multi-state. I will, depending on the disciplinary terms of that multi-state, I may have to bring this back to you all for further to see if you all ultimately agree with that, agree and want to sign on with it. But that would probably be the best way to go about this.
Okay. So I think we're all in agreement now to refer it over, and I can make a motion if you guys would be willing.
Go ahead.
I make a motion to direct this to the litigation counsel to explore settlements through the multi-state channels.
Second.
Second. Okay, I have a second. Let's have a vote. All those in favor say aye.
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 I am also an aye. The motion passes. All right, I think that's it for our complaint investigations. So let's go on to licensing matters.
Licensing matter A is complaint number 2025-1082.
So, sorry to interrupt. I just want to make sure that Board Member Williams gets back before
Oh, sorry.
you read. No, you're good. I'd hate for you to have to reread it
Oh.
all again. So
I only see 4 on my screen, so I didn't know.
Hold
Sorry.
on, I'm back.
Back.
Hello. All right.
Okay. Licensing matter A is complaint number 2025-82. On May 2nd, 2025, the applicant entered into a consent order with the State of Washington Department of Financial Institution. The consent order called for a 5-year revocation of the applicant's Washington mortgage loan originator license. The revocation was stayed and the applicant was ordered to cease and desist from conducting business in a manner that is injurious to the public or violates laws and regulations. The stayed revocation will remain in effect through May 2nd of 2030, as long as the applicant complies with the order. The license revocation will be terminated on May 2nd, 2030, if the applicant has complied. The applicant is currently licensed in 9 states, 5 of which are inactive. And we do not have a recommendation as usual, but Investigator Martinez can help answer any questions.
I'd like to open this up for any discussion.
I had a question for staff. So the respondents made a statement on July 22nd that says he did report the discipline in Washington on his application, but I think I saw in the report that it said he did not report it on the application. So which is it?
Hold on a second. Okay, so it's not disclosed on the application, but it's disclosed in the NMLS registry. So that's this dual system of having 2 places to disclose everything. I think it kind of creates some headache for licensees, but it is disclosed in the NMLS registry. So we can't say that it was not actually disclosed.
Okay. And is there anything, because I was also confused about this in the application, is there anything in the application where you're also asked to disclose it and then the applicant can say yes or no, or?
So the application asked about criminal background. I
Right.
have seen some scenarios where applicants will upload the discipline documentation to the criminal question, but typically across the board, they're going to disclose it on the NMLS registry because every regulator sees it there.
Okay, all right, fair enough.
No problem.
Well, this is another case where in his written statement, he denied all wrongdoing and basically just said, oh, I implemented some training. And no letters of recommendation. I'd like to put out there, we've done this before, that it really does make a difference if an applicant goes or, goes to the trouble to get some letters of recommendation and write a personal statement and that kind of thing, because it helps us.
Extremely.
I'm with you, Shirley. Another thing that has me concerned on this is that the revocation in the other state is simply on a stay for several more years.
Right.
That's a very different, that changes things for me.
They are licensed in other states, correct?
Yes.
It says 9 states,
Yes.
and 5 he's inactive in.
Oh, that's right, inactive. Okay.
Still is licensed in the state where the discipline had occurred as well.
So the state there still letting them practice after they.
Yeah, correct. As long as there are no violations, and up until 2030, he can still practice. And then if there are violations, then potentially it could be revoked permanently.
So it's sort of a probationary license or a.
That's correct.
Yeah.
And that was my feeling with it. Can we do a probational license for that long? I know that the logistics of watching it, obviously, if there's trouble, that's when it comes to us, but there's really no study there. But if there's something we could do for a 5-year probational license, I don't know, that seems very
Yeah, that's a long time.
Yeah.
What's the minimum amount of time on or maximum amount of time on a probationary license?
That's
Staff.
a good question.
I don't know that there's a max amount of time, but maybe Anthony would know better.
I don't believe there's a maximum amount of time. Your authority just says that you can place a license on probation and set the terms of probation. So I read that broadly, and you got a lot of wiggle room to do what you'd like.
Marcia, any guidance on past examples of things like this that have been decided on probation?
Well, I think this is kind of unique, but I do think, I mean, if you wanted to, you could put him on probation to run concurrent with kind of that pending revocation cycle that he's on in the other state.
Okay.
Yeah, I kind of liken this to the rule that says if someone has had a license revoked in another state, then, you know, we have to take that into consideration. That is a basis for denying or revoking. So I kind of like that idea that we go concurrent with what the state of Washington is requiring.
I agree.
I like that too.
So I'll make a motion for approval with a probationary license until December 31st, 2030.
I second it.
We have a second. Do we want to add anything else, or is it just, do we want to have any anything with that? Like, or are you guys okay with that? Like saying if there's any discipline actions during that time frame, we would have to come from the board and review, or do you just want to leave it as a probationary for the 5 years?
And
We would get notified, right, if there was a revocation there, right?
That's correct. We
think
would receive an NMLS alert.
Okay.
And sorry to interject, board members, but it sounds like, based on the board's discussion, that you would like the terms of your probationary license, assuming it's voted and approved, would be compliance with the terms of the other Washington discipline. Is that it?
Correct.
Correct.
Okay. If that's, I would just make a note of that in the motion. And I would also, just to be safe, I would add strike that. I would just make sure that that is clear in the.
Okay, I'll restate the motion that we approve the application to issue a probationary license, the terms of which will be the same as what is happening in the state of Washington, and will run concurrent with the period that the state of Washington has issued to the respondent, which will run through, I apologize, May 2nd of 2030.
Do I have a second?
Second.
All right, let's have a vote. All those in favor say aye.
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 I am also an aye. All those in favor say nay. All right, motion passes.
Okay, the next is licensing matter B, complaint number 2025-1136. On December 30th of 2024, the applicant entered into a stipulation with the Colorado Division of Real Estate Board of Mortgage Loan Originators. The stipulation ordered a $1,150 fine and public censure. The fine has been paid. On August 14th of 2024, the applicant pled guilty to obstructing firefighter medical, a class 2 misdemeanor. The applicant was ordered to pay a $1,027.50 fine and complete 9 months of probation. The fine was paid and probation was completed on June 25th, 2025. The applicant is not currently licensed in any other states. We do not have a recommendation, and Investigator Martinez is here to help answer any questions.
Thank you. I'll open it up for discussion.
So based on my understanding, the misdemeanor that the applicant was convicted of does not qualify for one of the criteria that would require us to automatically deny.
That's correct.
So my
Yeah.
understanding is we do have discretion here. I like the fact that the application truthfully reported it and has fully satisfied the stipulation that they have. That I like.
I would agree. He took the initiative to correct a wrong.
Yeah, all the fines are paid and the probation is complete. I'm agreeing it's there, sure.
I'll make a motion for full approval.
I'll second it.
All right, we have a motion and a second. All those in favor say aye.
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 I'm also an aye. All those opposed say nay. All right, license is approved.
The next is licensing matter C, complaint number 2025-1037. On November 10th, 2011, the applicant's Florida mortgage loan originator license application was denied due to failing to provide requested documents in a timely manner. On January 20th of 2009, the applicant's Massachusetts mortgage loan originator license application was denied due to criminal convictions. Those convictions were later dismissed on March 17th of 2009. The applicant is currently licensed as a loan originator in the states of California, Florida, Texas, and Washington, and we do not have a recommendation. Again, Investigator Martinez can help answer any questions.
Thank you. I'll open this up for discussion as well.
So there's a lot of listed, I guess, crimes are not the right word if you're not convicted, but there's one as recent in 2024 that says force ADW not with a firearm, and then it says no arrest. So how does this show up or no charges found or no record found? I don't understand how this got listed if.
So sometimes if there are charges filed or if there is an arrest, but there's no actual conviction, it will sometimes show up as no charges filed or as no conviction. So in this instance, the looks like the police agency that would have handled the criminal matter, they have provided a statement stating that there are no records of this arrest. So yet unusual, but the document does appear to indicate that there have been no charges filed for this offense. So not something that we can count as a conviction unless there is an actual disposition.
Okay.
And to me, anyway, it seems like just a history of a lot of, whether you're convicted or not, a lot of violent type behavior stuff. I'd be a little concerned about the public. Just kind of my thoughts, just because it seems like just chronic.
Yeah, and I mean, there was a lot of information to go through with regards to those offenses. However, if we don't have convictions on them, I don't know that we could use them as a basis for denial, or if they're dismissed, completed and dismissed, I don't know if we can use those as grounds for denial.
That's the tough thing, because the pattern of things that are shown here is really concerning to me, just from a general public perspective.
So do we do something from a probationary status, providing no other conviction or something along that line?
Yeah, you can definitely do a probationary, but the same thing too is if it's something happened in the future, it would come back to us whether it's probationary or not.
Okay.
So we could grant a license or do a probationary. Since he doesn't have a license, oh wait, he does have a license in other places. So, you know, we could definitely do probation or not. What do you guys want to, what you guys want to do?
I had a question about Exhibit 6.
Yeah, let me open it up. Our G drive is moving a little slower than usual, so just give me a moment.
Okay.
It seems to be freezing with opening some of these documents. Okay, I'm in it.
Okay. So down at the bottom, it talks about the regulatory action.
For Massachusetts, the denial.
Yeah. So
Okay, yeah.
there isn't anything that I saw on the Colorado application that asks about past denials. Is that
Right.
true?
That's correct. And so we rely on both the application and the NMLS registry to get information on anything that's not covered in our application questionnaire.
Okay, so the past denials were reported in the NMLS, correct?
That's correct. Yes, sir. That's
Okay,
correct.
all right. So it's not that the applicant did not disclose the past denials.
Correct. Yeah. And I mean, I think it also raises the question of if they don't disclose it on the application. I know a lot of applicants will sometimes have a licensing manager complete their applications for them. But it is disclosed in the NMLS registry. I think we have a hard time making an argument that they didn't disclose it outright.
Okay.
You know, we could say that, okay, it wasn't listed on the application, but ultimately the information is available to us through the registry, or should be through the registry,
Okay.
through the MLS.
Okay, all right. I just want to make sure of that.
You know, the probationary license thing, I don't know that we have any grounds aside, you know, legal grounds, aside from the fact that we're concerned about past, you know, history of issues. I don't know that there's anything specific that we can point to in rules or statutes to base a probationary license on.
And after hearing the, thoughts on it, I would agree as well. I'd pull that back.
Yeah, we actually don't have any, and we've talked about this before. There is actually nothing that guides those or watches those or has anybody, checking in on those. So really, it has, just a wording. Maybe it's just, hey, we were worried about this in the probationary portion, but there's nothing to that unless the person actually got in trouble and it came back in front of us again, that we would see that, hey, we initiated an initial probationary license, but there's really no teeth to that portion of that. It's just more of I think, a clerical on our side.
Well, then, based on that, I would make a motion that we go ahead and approve the license.
Second.
All right, I've had a second on a motion. All those in favor say aye.
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 I am also an aye. We'll grant a positive opinion.
The next is licensing matter D, complaint number 2025-1311. On January 29th of 1992, the applicant entered into a plea of guilty to theft, a class 4 felony. The applicant was ordered to complete a 2-year deferred sentence and judgment and pay a fine of $710. The applicant was also ordered to complete 2 years of probation concurrent with a deferred sentence. The fine was paid and the deferred sentence was completed on August 11th, 1993. 4 class 5 felony charges were dismissed. The theft conviction did remain. On May 23rd of 2025, the applicant's Colorado mortgage loan originator license application was denied due to conviction of crime involving theft and was subsequently withdrawn. The applicant is not currently licensed in any other states, and we do not have a recommendation. And again, Investigator Martinez can help answer any questions.
I'll open this up for discussion. What do you guys think?
So
My
I noted,
understanding is that by statute, we have to deny. That's my understanding.
Yeah, I think we need to understand that it was fraud. Obviously, it was 30 years ago plus, but it was a fraud portion. And I believe by statute, like you said, we're mandatory basis that we have to deny. Yeah. Does everybody feel that way?
right.
Yeah. And actually, I think the statute is 12-10-7112BI.
Yep.
So I'll make a motion if that we uphold our denial based off of the mandatory requirement to deny based of fraud, and that statute is 12-10. 2025-7112BI. Do I have a second?
Second.
All right, have a vote. All those in favor say aye.
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 All those opposed say nay. That was unanimous.
And board members, sorry to interject. Would you like to provide this applicant the option to withdraw?
I would say no, because, I mean, we have,
Clear.
you know, the applicant has come back for a second time. And I think being clear that we really don't have a choice is good at this point.
I agree.
Agreed.
I agree too.
All right.
All right. I think we are complete with licensing matters. Move on to ESP matters, but I don't think we have any. Penny, is that correct?
Yes, that is correct. No matters for you today.
Thank you very much. And then the next is Attorney General matters. It shows none as well. Is that correct?
That is correct.
All right. Sounds good. And then we already went over the executive session matters portion of that. So are there any other agenda items that maybe we have thought about during this meeting that we want to add to the next meeting?
Nope.
Nope.
Nothing? All right. Well, then I'm going to say thank you very much, everybody, for showing up. And I wanted to see, is there a motion to conclude our meeting today?
So moved.
I'll second.
Second. And then everybody in favor say aye.
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 I am also an aye. Thank you, everybody, for all your work and all your time. Have a
Thank
great
you, board
day.
members.